Choosing the wrong work visa for your transition to the US can end up costing you tens of thousands in legal fees, lost at wait time exceeding a year or more, and create problems or delays with launching or expanding your business in the US. Most people don't even realize the differences between the H-1B and the L-1 visa. In this video, I'm going to explain the differences between the H-1B, the L-1, who best qualifies for each of those two visas, and which one would be the most appropriate in your situation. By the end of this video, you'll have a better understanding of whether the L-1 or the H-1B is the best way for you to move forward. Hello everybody, my name is Charles Rather. I'm the managing partner at AmLaw Group, where for nearly 20 years we've been assisting entrepreneurs, investors, and other business people in making a transition to the US to develop, expand, and grow their business in the US market. If you're considering a choice between the H-1B or the L-1, or possibly another option, leave your comments or questions in the comment area below. So to begin with, maybe the first thing is to understand that the L-1 and the H-1B really aren't interchangeable between each other. They're really designed for two quite different scenarios. And so I'd like to try to dissect what those scenarios are and then go into the details of the L-1 and H-1B to help you understand which is most appropriate. Now, the H-1B is a temporary work visa. The L-1 technically is also maybe a work visa, but as you'll see in a few minutes, it's more aligned with owners and founders as opposed to just employees. The H-1B is, like I mentioned, a temporary work visa. It's granted through a lottery system that's conducted in the spring of every year. And the first problem with the lottery, as you can imagine, is you don't always win, right? Not everybody who applies in the spring gets a seat or gets a visa spot because the number of applicants almost invariably exceeds the visa quota each year. So the first issue with the H-1B is that it's on a lottery system. And I would say on average, chances are about 1 in 5 or roughly 20% that you would win a spot in the lottery. So again, that's the first potential issue or problem with an H-1B. Now, maybe on the good side of the H-1B is there's no investment that's required per se, nor do you have to have any employment history with the employer or any of their overseas affiliates. You could be a completely new hire, somebody who's never worked for this structure or this company before, and you certainly don't have to invest any funds. The most common that we deal with is with executives and managers. And in most of those cases, the L-1 is being applied for by the primary owner of the overseas company. So you have an owner of a company, that person is also a president, CEO, some high executive position at the foreign company, and that person wants to come to the US to either open up a new branch or a new subsidiary in the US or possibly acquire an existing branch or an existing company, and they're applying for the L-1 in order to allow them to come here and work from the US. So first of all, as you can see, it requires a certain investment because you have to open a new business or buy an existing one in the US. Most cases, the main applicant is also the primary owner of the foreign company, and he or she is becoming the owner of the US company and then applying for the L-1. So you can see some of these differences already. Other big differences is that unlike the H-1B, the L-1 does not have a lottery. There's no quota. So you can always apply for an L-1 at any point in time. The other thing is that the L-1 is a little bit more flexible in terms of educational requirements. With an L-1, there's absolutely no educational requirement. One thing I also wanted to bring your attention though is with the L-1, you do need to have at least 1 year of experience at the overseas company. So an L-1 is not going to work if you're just a new employee, you've never had any kind of relationship with this company overseas before, and you've just come off the street and started working for them. That will not work an L-1. You have to have at least 1 year of experience in the previous 3 years before you enter the US. So let's get into the nitty-gritty here. With the H-1B, like I mentioned, there's a lottery system. That lottery system changes a little bit year to year based on the president and political wins, but generally the system is such. And they've made it a little bit simpler and less expensive recently in that first the employer has to register with the government and then file an application on your behalf. Those fees are really pretty small. You don't even need an attorney to do that part. Then if you win a lottery spot, then you would start the legal work with your attorney. One thing to keep in mind is a $100,000 surcharge that the Trump administration imposed on the issuance of H-1B visas. Now that surcharge was struck down by a district court in June of 2026. However, the US government immediately appealed it. It's currently under appeal, so you need to follow any recent developments in that to see if that overturning of the $100,000 fee will stay in effect, or if they'll go back and revert back. But as of today, it's still in effect. Now, what's important to keep in mind is that is valid on the issuance of H-1B visas. So if you're in the US in another status and you're changing your status, you're here as a student, you're here as a tourist, you're here on an E2, I don't know, and you change your status to an H-1B in the US, you don't have to pay the $100,000. It's only paid if you go for a visa at a consulate. The other thing to keep in mind with an H-1B is, as I mentioned, you have to have a bachelor's or adequate education. And I believe it's 3 years of experience per year of education. So you need at least 12 years of progressive experience in your field. But the thing is also with an H-1B is it's a specialty occupation. So they really pay attention to specialty occupation, meaning, if it's just kind of a general managerial position you're taking on and stuff like that, that can be problematic. And so sometimes people just don't have that particular skill set or experience that would qualify as a specialty occupation. Now with the L-1, you don't have any of those issues. There's no lottery, there's no quota, there's no $100,000 surcharge, there's no requirement that it be a specialty occupation. And that doesn't mean everything is easier with the L-1. Like I said, you need to have at least 1 year of employment experience working for an affiliated overseas company. And if you're doing an L-1A, you need to show that you've had at least that 1 year of experience as an executive or a manager. So they're gonna look at who are your subordinates overseas, how many subordinates did you have, and would that qualify as an executive or high manager? To answer those questions, I would say in general, as a general rule of thumb, for an L-1A, we wanna show that the applicant has managed or overseen at least probably 10 subordinates at the overseas affiliate. 8 would probably work. Anything below 8, I think you're pushing it. Again, it's a judgment call by each officer, but from our decades of experience, we have a good feel for what they like. And of course, what they like has changed over the years. It's probably disappointing for people to hear that 15 years ago, we would show people were managing only 3, 4, 5 people, and that wasn't a problem. But that's changed over time. So again, if you're applying for an L-1A, we've got to show you have that experience managing roughly 10 subordinates or more, and show that your job duties were specifically related to being an executive or high-level manager. Meaning, if you're, let's say, the CFO of the company, they don't want to see you crunching all the numbers for the day-to-day, bookkeeping and even putting together the financial statements. They want you to be managed the people who are doing all that work. Now, there is a second type of L-1. It's called an L-1B. That's not for executives or managers. It's for people with specialized knowledge. So you don't necessarily have to prove that you were overseeing or managing 10 people at the overseas company, but we have to show that you have some specialized knowledge that's generally not available on the market. It's rather restricted, rather unavailable, and you're coming to the US to apply your skills and knowledge here at the company in the US. There can be some flexibility with the L-1B. I mean, I'm not saying it has to be only rocket scientists or electrical engineers. I've seen consultants, real estate consultants, technical personnel who have good knowledge about technical equipment or special equipment that's used by the company, and let's say they're selling it here in the US or repairing it, and that person needs to have experience in operating or repairing that kind of equipment. So you can get a little bit creative. You need to consult with your attorney to determine whether that person really would qualify for an L-1B or not. But again, that's also a second option as for an L-1 visa if you're not an executive or manager. To summarize then, what does this all mean for you as you're planning your strategy to the US? Again, if you're the owner or co-owner or co-founder of an overseas company and you're looking to expand here in the US, most cases I would say the L-1 is your better route. It's also a good route if you want to bring over some of your highly skilled and highly placed executives or technical personnel to the US. H-1B is much better for temporary workers, for people who aren't necessarily affiliated or working for your overseas affiliate, but people you want to bring on board and have them working in the US. And sometimes we have companies that they might do several people on an L-1 and they bring several people over on the H-1B just because they had luck, qualifying for the lottery, or we had doubts about whether we could get them to qualify for an L-1 or an L-1B. And in those cases, then the H-1B might be a better option. If you're considering the L-1 or H-1B or possibly some other option for your business expansion or business growth plans here in the US market, please reach out to us below using some of the links below or contacts, either email, phone calling us, or using the links in the description below to set up a one-on-one conversation, an appointment with myself or somebody from our team in order to help guide you in making your choice between an H-1B or an L-1, or looking at another option to make your transition to the U.S. as quick and successful as possible.